Evening, welcome back to the channel. This is a follow-up video from that incident that happened to me in Subway on Friday the 9th. Sorry, it's about the second time I've recorded this. I've just had next door's takeaway delivered to me because she was on her way back from the pub. I didn't eat any of it. No, that's it.
You give me the money for it, so I can buy it again.
Yeah.
Thank you.
One of them's got a drink in it, so be careful.
I know.
To Subway, which I'll now do my best to read to you. Okay, notice. Notice to agent is notice to principal. Notice to principal is notice to agent. That means if the top of the company gets served a notice, it's his responsibility to inform everybody of it. And the same the other way around. If somebody at the bottom of the company gets served a notice, it should go all the way up to the top. Dear sir, this is a notice, a legal instrument. Do not ignore it. Read it carefully. It informs you. On the 9th of October 2020 at approximately 1 PM, both you and your staff breached 1. My human rights. 2. The Equality Act 2010. Maxim in law. Ignorance of the law is no defence to the law. Upon entering the store, I was asked to wear a face mask. I informed you and your staff that under the above act, you are forbidden from asking me that question. I then informed you and your staff that it is a breach of the 2005 UNESCO Declaration on Bioethics and Human Rights. Maxim in law. He who chooses not to exert his rights has none. Think about that, what it means. If you don't stand up for yourself, if you don't know how to stand up for yourself, then you're going to be trodden all over. You have to exert your rights to have any. The government advice is not to challenge people to wear face coverings. This is for good reason, because both you and your staff may be personally liable for an offence under the Equality Act 2010. On summary conviction, you would be liable to pay a fine of up to £5,000 under Section 112, Aiding Contraventions of the Equalities Act 2010. And under Section 119, your member of staff would be liable to pay compensation between £900 and £9,000. Link provided. However, to avoid burdening the court system, I have the option to serve you with a sworn signed affidavit of truth, signed under penalty of perjury with full commercial liability, which you would then have 30 days to rebut. Point for point with your own affidavit of truth, signed under the same criteria. Failure on your part to rebut would mean I would be free to raise a commercial lien against you with a financial remedy of my choosing. That means it's not £9,000, it's not £5,000. I choose how much my damages are and have it placed on the public record. Once placed on the public record, I would be free to invite debt recovery agents to collect the debt on my behalf and begin to inform credit reference agencies should you refuse to pay. In the 1930s, Jews were refused service in shops. Later, in 1961, at the Nuremberg trials, a Holocaust survivor and principal witness against Adolf Eichmann collapsed, sobbing uncontrollably on the floor when he came face to face with Eichmann in court. When Mr. Dumont was asked after the trial why he collapsed, he replied, "No, it was not hatred. No, it was not fear, nor was it the horrible memories of Auschwitz. Rather, I realised as I saw him sitting there that Adolf Eichmann was not the godlike army officer who had sent many people to their deaths. When I saw him sitting there, I saw that he was just an ordinary man. But now listen. I was afraid about myself. I collapsed when I looked at him, and that I, Yehiel Denior, realised I was capable of doing the same thing. I am exactly like him. In fact, I discovered there is an Eichmann in all of us. The following quotes are taken from www.gov.co.uk on Sunday the 11th of October 2020, which would be included but not limited in my affidavit of truth, meaning for a commercial lien not to be raised, you would have to rebut the following in substance. Some people may feel more comfortable showing something that says they do not have to wear a face covering. This could be in the form of an exemption card, badge, or even homemade sign. This is a personal choice and is not necessary in law. Some people don't have to wear a face covering for health, age, or equality reasons. No one who is exempt from wearing a face covering should be denied entry if they are not wearing one. No person needs to seek advice or request a letter from a medical profession about their reason for not wearing a face covering. Think about that. If businesses take steps to create a physical barrier or screen between workers and members of the public, then staff behind the barrier or screen will not be required to wear a face covering. That means all you guys who work in trade counters or in Subway, you were told you've got to wear a face mask. If there's a barrier up, according to the government website, you don't have to wear a face covering. You're being lied to, people, okay? Final quote from the government website. Government and some operators have produced cards and badges which you can choose to wear to show you are exempt. There is no requirement to do this though, and if you rely on an exemption, transport staff should not ordinarily ask for evidence. So moving on. First and final opportunity to resolve this matter. If you wish to resolve this matter without the possibility of facing criminal prosecution and or suffering financial losses for the next 99 years, you can do so by agreeing to the following. Write a full, frank, unmitigated and sincere letter of apology signed by the store manager, Sam, the member of staff who refused me service, the franchisee owner and the head of customer services of Subway UK, along with one free foot-long sandwich of my choosing. Should you choose not to take up this extremely reasonable and generous offer, you, your staff and the franchisee owner face the very real possibility of criminal prosecution and or total asset stripping via a commercial lien. I have provided you with the courtesy of including a document titled What is a Commercial Lien? I wish to inform you that lying on an affidavit of truth, your rebuttal, would be a criminal offence and immediately be an attempt to pervert the course of justice on your part and subject to a maximum term of imprisonment of 7 years. This offence extends to any police officer or judge who attempts to interfere with an affidavit of truth, in addition to the possibility of other charges, including misconduct in public office, which currently carries the maximum term of imprisonment of life imprisonment. What that means is judges, coppers, they can't touch this document. Not long left now. Maxim in commercial law. A lien or claim can be satisfied only through A, rebuttal by counter affidavit point by point, B, resolution by jury, C, payment or performance of the claim in full. Please contact me when my letter of apology is ready for collection from the store on the telephone number provided above. If I do not hear from you within 7 days of the date of notice, This will be deemed to mean you have chosen, stroke prefer, the other options listed in this notice and at my disposal. Do not ignore this notice. All rights reserved and non-waived. This notice is sent and served in good faith and without ill will, vexation or frivolity. Right, so this is just a bit of an addition to my Subway notice video, which I may or may not include. I just wanted to further explain. I meant to do it in a video, but you know, it's hard recording live and stuff without editing. About that maxim in law, which states, "He who chooses not to exert his rights has none." What that means is, you've got to get yourself informed, and it may seem quite daunting, but it's not impossible. Certainly it's not impossible. In fact, it's quite easy, because we are all required to follow the law, are we not? And if we're all required to follow the law, anybody who can be held culpable in law must be able to understand it, otherwise the system is rigged. Therefore, the law is actually quite simple to understand once you kind of scratch the surface into it. But what you have to do is you have to be able to stand up for yourself. And it feels like you're not bullying people, but it feels like you're doing something wrong by just actually stating your rights and informing people of facts. And what I would say is, you know, this channel is not offering any sort of legal advice. Just read the description. It's a vlog about me, my job, and my dog, and I'm just logging what's going on in my life for my daughter, actually. So you can see what I've been up to in that while she was young. But going back to that maxim is, sometimes you will not only have to state your rights, you will have to do it in quite a not aggressive, vociferous manner. You have to be able to vocalise what you know and force it up on the other person, whether it be a copper, a magistrate. When you start getting up to, you know, coming face to face with judges, they know this stuff, so you don't have to be quite as forceful. But these low-level clowns, you have to make them think that you are more powerful and more informed than they are. And there's a reason for that, because knowledge is power. And they've been misinformed, and they've been lied to too. And they're just going on their basic fundamental knowledge of what they've been told. And they won't understand that they've been lied to. They think they've got authority over you, and they don't. I will maybe at some point, I don't know, maybe make a video about that. I think I've previously mentioned it, but, you know, people only have authority over you if you give them that authority.